Hi, Con Law class. In this video, we're going to talk about the fundamental interests branch of equal protection. The concept of a fundamental interests branch of equal protection can be a little bit confusing because we have already talked about suspect classes. So if we've talked about suspect classes, why are we now talking about fundamental interests? Part of the reason is the history of the concept of equal protection within the 14th Amendment and how that develops after the Civil War and then later on in the Civil Rights Movement. So recall that some of the cases we looked at under the 14th Amendment about race, for example, immediately after the Civil War were really under the Privileges and Immunities Clause of the 14th Amendment. And the jurisprudence really only substantially develops later on the equal protection front with respect to race, and really substantially with respect to race in the Civil Rights Movement, in Brown v. Board of Education, and in cases after that. And then the question of whether there are other suspect classes that require some kind of heightened or strict scrutiny under the Equal Protection Clause, whether it is gender or age or disability, really follows on the jurisprudence that develops in equal protection under the 14th Amendment relating to race. So that is one strand of equal protection jurisprudence. And if you're seeing distinctions that are being made based on some kind of inherent characteristic of a person, then you want to think about it mostly in terms of that strand of equal protection. Now you might be thinking, well, wait a minute, what about alienage? We have seen that alienage is a suspect class, and alienage is not an inherent characteristic of a person, it's a legal distinction. The alienage is its own category because it's its own category in the constitutional context that we've looked at, and that's why we're looking at alienage as a suspect class. In this fundamental interest strand, what we're looking at is classifications that would normally receive only a rational basis review because they don't involve a suspect class, or there's not an argument or a viable argument that they involve a suspect class. But they might receive heightened review nonetheless because they involve some kind of right or interest that is thought to be fundamental in general under the Constitution. So what are rights or interests that so far the court has said are fundamental under the Constitution, and therefore that distinctions that affect those interests will receive heightened scrutiny? Well, they include voting, and in particular the denial of the right to vote or the dilution of the right to vote, access to the courts or to the judicial process, and interstate migration. Although, as we have seen, really the contemporary jurisprudence on interstate migration, that is the free ability to travel between states, is reviewed under strict scrutiny under the 14th Amendment's Privileges and Immunities Clause. There have been cases brought asserting that the court should recognize heightened or strict scrutiny under the Equal Protection Clause for distinctions in education, welfare benefits, and housing, but the court so far has not recognized any of those classes under the fundamental interest branch. Now again, this can be a little bit confusing. If someone is denied equal access to public education based on race, a suspect classification has been made based on race, and therefore it's an equal protection claim based on race. Same thing with welfare benefits, same thing with housing. But if the distinction is simply that some people, not based on a suspect classification, have greater access to education, or greater access to welfare benefits, or greater access to housing, that in itself is not going to be viewed under strict scrutiny. And there are a number of reasons why the court so far hasn't done that, which you may or may not agree with, but some of those reasons include that, at least concerning some of these sorts of things, there are going to be differences among individual people based on skill, based on industry, based on chance, based on luck, or any number of other factors that give rise to differences in wealth, for example, among individuals that aren't directly based in suspect classifications such as race. And therefore, to call for strict scrutiny of such distinctions under the Equal Protection Clause would really end up being a kind of a form of social engineering that the Constitution doesn't really contemplate. A possible response to that position, of course, is that there are distinctions based on what we call skill, or what we call intelligence, or even industry, or certainly chance or luck, that, given the history of the United States, inevitably have roots in certainly racism, for example. That simply the way that our society has historically developed is going to allow certain people to have advantages that may not be de jure advantages, but maybe de facto advantages that have deep roots in a history of racism or sexism or other deep cultural animosities. And that's really a big argument about, how government should be structured and to what extent the Constitution can remedy some of those deficits. It's a really interesting argument. For our purposes, in terms of the existing constitutional doctrine and rules, state that differences in access to education or welfare benefits or housing or other sorts of things like that are not de jure based on suspect classifications and are in some way or another aided and abetted by the law are going to be looked at under a rational basis review and are really a question of political concern and not questions that the court can directly address.